In a move that harkens back to the old consumer saying, "not as satisfying as advertised," the Ninth U.S. Circuit Court of Appeals Thursday dealt a major blow to California's gun grab political forces, while offering merely a pyrrhic victory to advocates of free speech and the right to keep and bear arms. How can these two seemingly disparate facts coexist? We'll dig in and see. Hi everyone, I'm Gardner Goldsmith for MRC-TV, and here's the story. Bearing Arms' Cam Edwards offers a succinct overview of the situation and of the Ninth Circuit Court decision. First, he notes, quote, "Writing for the majority, Judge Kenneth Lee ruled that the law forbidding marketing and advertising of firearms that reasonably appear to be attractive to minors is likely to infringe on the First Amendment, given that the statute is so broadly written that advertisements aimed at adults who can lawfully purchase a firearm would be swept up in its provisions." The California gun-grabbing politicians and their attorneys based much of their so-called justification for subsection 22949.80 of the California Code, aka the so-called Marketing Firearms to Minors statute. Well, they based it on already extant judicial and legislative fantasy that has seen both the feds and states claim a power to control what they categorize as commercial speech, which in turn actually goes back to a terrible and terribly important Supreme Court ruling in the 1942 case called Valentine v. Christensen. In a unanimous decision, the FDR allies of the time on the court made numerous conceded errors by, first, not acknowledging the actual wording of the First Amendment, which prohibits only Congress from infringing on the right of free speech, and second, not noting the speech protection enshrined in the New York State Constitution. Since the Valentine case centered on whether the government of New York City could prohibit a man from handing out flyers for his business, and the New York State Constitution prohibited the state and its sub-governments from infringing on the right of speech, anyone with a sense of logic and fairness easily could determine that the move by New York City was wrong. But, of course, the FDR pals on the 1942 Supreme Court claimed it was perfectly fine to suppress what the government called commercial speech. And regardless of the logical pit of doom that creates, forcing even fiction writers who sell their books, i.e. who engage in commerce and even promotion of their work, to stare into the abyss, well, the fatuous political players who seem ever comfortable in shaving away our liberty have adopted the commercial speech canard. Which brings us back to Thursday and this fake victory for speech and gun rights advocates. Check out this portion of the decision. Quote, "While California has a substantial interest in reducing gun violence and unlawful use of firearms by minors, its law does not directly and materially further either goal. California cannot straitjacket the First Amendment by, on the one hand, allowing minors to possess and use firearms, and then on the other hand, banning truthful advertisements about that lawful use of firearms. There is no evidence in the record that a minor in California has ever unlawfully bought a gun, let alone because of an ad, nor has the state produced any evidence that truthful ads about lawful uses of guns, like an ad about hunting rifles in Junior Sports Magazine's Junior Shooters, encourage illegal or violent gun use among minors. Simply put, California cannot lean on gossamers of speculation to weave an evidence-free narrative that its law curbing the First Amendment significantly decreases unlawful gun use among minors. The First Amendment demands more than good intentions and wishful thinking to warrant the government's muzzling of speech. The majority of the Ninth Circuit ruled not that speech suppression, i.e., banning ads for guns that the politicians might claim are targeted at people who are underage, however the government wants to interpret that. They didn't rule that the speech suppression was verboten in California, but that there wasn't a sufficient reason to block any such ads. Note that in what I read earlier, the court actually claims that the state has a substantial interest, as they say, in also, as they say, reducing gun violence, but that this current suppression of speech does not directly and materially support that goal. Which makes us ask, what if the judges of the Ninth Circuit actually thought that it did? Well, there's a big, dark problem in that, and it is essential that more people recognize that problem. At the heart of this mistaken approach to rights is the widespread and long-standing fallacy that there can be a compelling state interest in some sought-for government goal. But the term compelling state interest is a logical and philosophical fraud. It's a euphemism that's always open to wider interpretation by those who occupy government offices. And it's always open to wider interpretation because there's no such thing as a compelling state interest. States don't have interests. Only human beings have interests because each of us has natural rights. States aren't human beings. As such, they have no magical interests at all. Those who run the offices of the state at various times spew out what they say are interests, often purporting that these are the interests of the people, when, of course, each person himself has his own interests and rights that are actually being overridden by the state, or they're being amplified at the expense of someone else's interests and rights. Or we can put it this way, as the great 19th century economist and philosopher Frederick Bastiat said, quote, "The state is that great fiction by which everyone tries to live off of everyone else." This distinction between the state and real people not only is important, it shows us an assumptive political and judicial sabotaging of our rights that's much more widespread than just the halls of the Ninth Circuit. As a result, it's important not to candy coat this decision as a victory for free speech coming out of the Ninth Circuit. The ruling doesn't question the concept that at some other time, government agents and judges might agree that there's some magical, compelling state interest that they make up. And then, goodbye rights. The real interest is in the rights of people to be left alone, free from coercion from others. And right now, the others who most often want to coerce people are those who occupy the offices of government. Thus, even with this ruling from the Ninth Circuit that puts an end to the California prohibition on gun ads that might attract kids, we can learn more. We can see that the state is not a person, has no rights, and has no interests at all. We can celebrate this minor win. But also, we have to acknowledge that hidden within the ruling, the Ninth Circuit reinforced a fallacy that stands in absolute contradistinction from our rights. Thanks for hanging out, everybody. Hopefully some good learning information there. Intellectual ammunition, I like to call it. Take it with you, spread it to others if you would be so kind. Please find us on Rumble where they don't censor us. Please like and share the videos far and wide, especially with students who might be interested in this sort of thing. You can find us on YouTube as well, where yes, they do censor us. Please double check that you're subscribed there. And of course, find us all the time at MRCTV.org. MRCTV.org. And while you're there, please consider contributing to the Media Research Center in its 36th year, fighting left-wing bias, and please visit the MRC Store. You can also find us on Facebook. You can find us on Instagram and TikTok. You can find us on Twitter. And on Gab, I'm at Gardner Goldsmith. And on Twitter, I'm at Gard Goldsmith. Thank you so much for joining me, everybody. Remember, please share the videos. For MRC TV, I'm Gardner Goldsmith.